Okay. So chapter 7 and 7A we'll do today. Chapter 7 is again subdivided into multiple parts. So overall chapter 7 is called as a chapter for process to compel the production of things overall, in which the part A, what we'll talk about is about summons to producer. So the person who is going to produce those things, how to put a summon to that person. So this is something we will start from section number 91. So section 91 talks about summons to produce document or other things. Now, this particular section, the wordings, if you read carefully, there are a couple of things which are very, very essential component of it. So whenever any court or any officer in charge of a police station considers that the production of any document or other things is necessary or desirable for the purpose of any investigation. So for the very first two line limits, I'll add couple of lines in Hindi also for you. So पहले दो लाइन में वेरी क्लियरली समन ऐसे लोगों को जो प्रोड्यूस करते हैं डॉक्यूमेंट उनके लिए है और फर्स्ट टू लाइन क्लियरली पुट्स अ बाउंड्री अराउंड इट दैट हु so a court or an officer or charge of in charge of a police station, if they consider production of any document which is necessary or desirable for the purpose of an investigation, inquiry, trial, or other proceeding under this code by or before such. Okay. So that is something which is defining the boundary. Now, such court may issue a summon. So when the court talks, they talk in the language of summon. So such court may issue a summon. But when we talk about in this section about an officer in charge also, so officer in charge gives a written order. It is not called a summon. Summon is only from perspective of a magistrate or a court. So such officer gives a written order to the person in whose possession or power such a document or thing is believed to be. So this says to the person whose possession or power such document is things believed to be. So both of these parties who are inquiring and who are asking to produce this document, either court हो या police officer हो, अगर वो समझता है कि आपके पोजीशन में और या आपके पावर में है उस डॉक्यूमेंट को आपको देने का, in both the conditions, required him to attend and produced him. Requiring him to attend आकर के आपको वो प्रोड्यूस करना डॉक्यूमेंट और टू प्रोड्यूस इट एट द टाइम एंड प्लेस स्टेटेड इन द समन्स और ऑर्डर. या तो आकर प्रोड्यूस करें या फिर प्रोड्यूस करें एट द टाइम एंड प्लेस स्टेटेड इन द समन और ऑर्डर. आपके समन या ऑर्डर में जो लिखा हुआ है उस जगह पे आपको उस टाइम पे लाकर देना है. Point 2 of the section says any person required under this section merely to produce a document or other things shall be deemed to have complied with the requisition if he cause such document or things to be produced instead of attending personally to produce the same. So someone to produce document or thing is more concerned about the document to be produced. डॉक्यूमेंट उस पर्पस से जिस पर्पस से आना चाहिए उस ट्रायल्स इन्वेस्टिगेशन इंक्वायरी से रिलेटेड, and the summon is more towards the person whom we believe that person can produce or the person has a power to produce that particular document. To merely to produce documents things shall be deemed to have complied. अगर आपने ये डॉक्यूमेंट को कॉज कर दिया प्रोडक्शन, आपने किसी तरह से प्रोड्यूस कर दिया, आप गए आपके एजेंट आके प्रोड्यूस करते हैं और whomsoever or howsoever you do it. So personally आकर देना is not mandated under this section. It might be under other sections, it is, but not under this section. Nothing in this section shall be deemed to affect section 123, 124 of Indian Evidence Act or the Bankers Books Evidence Act. We'll talk about it in a bit. And to apply to a letter, postcard, telegram or other document, any parcel or things in the custody of the Postage Telegraph Authority, because Postage Telegraph there is another section. अभी प्लेन रीडिंग का इस सेक्शन को पढ़ के इतना समझ में आता है कि ये एप्लीकेबल है किसी कोर्ट के लिए या किसी पुलिस ऑफिसर के लिए, वो भी जब उसको किसी पर्टिकुलर इन्वेस्टिगेशन इंक्वायरी ट्रायल से रिलेटेड इंफॉर्मेशन चाहिए और उसने समन या एज एन ऑफिसर एक ऑर्डर आपको इशू किया है जो ये समझता है ये पोजीशन आपके पास हो सकता है इस चीज का, या आपके पास पावर है उसको प्रोड्यूस करने का, बट इट डज सेज कि आपका पर्सनल अपीयरेंस इज नॉट रिक्वायर्ड मैंडेटेड इन दिस रेलेवेंस। आप किसी भी तरह से उस चीज को प्रोड्यूस कर सकते हैं रेलेवेंट टाइम पे और रेलेवेंट प्लेस पे। तो अभी ब्रेक डाउन अगर करेंगे सेक्शन 91 डाउन इनटू स्मॉल चंक्स, देन नंबर वन, यू गेट इन द नोट्स ऑल्सो। नंबर वन क्या इंपॉर्टेंट है? ऑथोरिटी टू इशू समन्स और ऑर्डर। तो ऑथोरिटी किसको है, ये सेक्शन 91 कहता है। तो ये ऑथोरिटी कोर्ट को है या फिर पुलिस ऑफिसर को है। ऑब्जेक्टिव क्या है? कि रेलेवेंट एविडेंस मिल सके उस पर्टिकुलर ड्यूरेशन में। कंप्लायंस विथ समन्स और ऑर्डर जो है वो बिना पर्सनल अपीयरेंस के भी पूरा किया जा सकता है। यू कैन डू इट विदाउट पर्सनल अपीयरेंस एज वेल। Limitations and exceptions are also called out in this particular section, which is does not override the provision related to privilege communicated to document protected under 123 and 124 of Indian Evidence Act, जो कि अ, इस जगह पे लिमिटेशन का काम करती है। बैंकर्स बुक एविडेंस एक्ट भी इससे बाहर है लिमिटेशन के अंदर। और पोस्टल टेलीग्राफ अथॉरिटीज भी इस सेक्शन के अंदर समन नहीं किए जा सकते। दिस इज देयर अनदर सेक्शन फॉर दैट। और फैसिलिटेटिंग जस्टिस करने के लिए इंपॉर्टेंस है ये। बैलेंसिंग एक्सेसिबिलिटी एंड प्रिवेसी, आपका प्रिवेसी अगर है या आप नहीं आ सकते हैं फॉर सब रीजन, तो बैलेंस कर रहा है। और एफिशिएंसी लाता है कि इट इज नॉट लिमिटिंग योर प्रेजेंस टू सक्सेस, मेक द सेक्शन 71 रिलेटेड ऑब्जेक्टिव सक्सेसफुल। तो सेक्शन 71 एक बहुत ही वाइटल लीगल प्रोविजन है जो कि विच एम्पावर्स कोर्ट्स और पुलिस ऑफिसर को डॉक्यूमेंटेशन टाइम पर मिलती है इससे। अदरवाइज हाउ वुड यू प्रोड्यूस? So this is about section 91. Now we talked about the in section 91 about that letters and telegrams, postal department ko we cannot ask under section 91 to produce things. So procedure as to letters and telegrams. So if a document, parcel or things in the custody of postal or telegraph authority in the opinion of the district magistrate. Now we very clear ना, यहाँ पे पार्टी बदल गई है आपकी। चीफ जुडिशियल मजिस्ट्रेट, court of session or high court wanted for the purpose of an investigation, inquiry, trial, or proceeding, which is same under this court, such magistrate, so all of these are magistrates, executive or judiciary, or court may require the postal or telegraph authority as the case may be to deliver the document, parcel or things to such person as a magistrate or court directs। यहाँ पे पुलिस है नहीं है। सो अभी तक फर्स्ट पार्ट है विच टॉक्स अबाउट द पुलिस ऑफिसर इज रिमूव फ्रॉम दिस सेक्शन। सो पुलिस ऑफिसर्स, प्लेन पुलिस ऑफिसर्स डू नॉट हैव राइट टू पुट एन ऑर्डर इन दिस सेक्शन टू आस्क द टेलीग्राफ और द postal authority to submit. It can only be done by magistrates, whether it's an executive magistrate or a judicial magistrate or a court. If such a document, parcel, thing is the opinion of any other magistrate, whether executive or judicial, or of any commissioner of police or district superintendent of police wanted for such purpose, he may require the postal or telegraph authority, as the case may be, to cause search to be made for and to obtain such a document, parcel, or thing pending the order of a district magistrate, chief judicial magistrate, or court under subsection 1. So, यहाँ पे if such a document, parcel, thing is in opinion of the magistrate, एग्जीक्यूटिव हो या जुडिशियल हो, और एनी कमिश्नर ऑफ पुलिस और डिस्ट्रिक्ट सुपरिटेंडेंट ऑफ पुलिस वांटेड फॉर एनी सच पर्पस, ही मे रिक्वायर द पोस्टल, आपको अगर पोस्टल डिपार्टमेंट से अगर चाहिए और टेलीग्राफ ऑथोरिटीज चाहिए एज द केस में बी, और द सर्च टू बी मेड, अगर कोई ऐसा सर्च करना है टू एम्पावर पॉइंट वन टू बी सक्सेसफुल, इन केस द पोस्टल एंड द officer or the employee from that particular organization is happy to produce, fine. If there is required some kind of search has to be made, uh, and detain such document, parcel पेंडिंग द ऑर्डर ऑफ डिस्ट्रिक्ट मजिस्ट्रेट, चीफ जुडिशियल मजिस्ट्रेट, वो इस सेक्शन के अंदर कर सकते हैं। सो ऐसे सेक्शन 2 के हिसाब से इफ वी सी द बेसिक ब्रेकअप ऑफ सेक्शन 92 ब्रेकडाउन, तो अथॉरिटी ऑफ रिक्वेजिशन, so it's a high level judicial request hai. Basically it's a judicial request. It might be a district executive magistrate or a judicial magistrate or a court of session or a high court, whoever is empowered to do that. Now procedure is issue of directive. So magistrate or court can direct the postal or telegraph department to deliver it, the parcel item, to the person designated by these judicial authorities. किसी को designate किया है, it can go to that person to ensure a direct and effective channel for obtaining the necessary item without any delay. जूनियर मजिस्ट्रेट्स एंड पुलिस अथॉरिटीज के लिए स्पेशल पार्ट है इन दिस पर्टिकुलर सेक्शन वेयर दे इफ अंडर दिस ऑर्डर if any other judicial executive magistrate commissioner of police या district superintendent police consider करता है document parcel or item essential for proceedings under the code they can initiate a search वो search कर सकते हैं इसके अंदर में detention and pending order is depending upon how the order had made by the primary magistrates. Ensuring evidence availability is one of the essential requirement which is completed by section 92 where either by just an order or either by through a search of these people mentioned in part 2 even these things could be searched and produced. So the importance of section 92 is ensuring from the perspective of postal and telegram department the evidence availability through a judicial support. So if you see the primary part 1 it talks about the judicial support. So it needs a judicial support. It balances the authority and efficiency in the legal process automatically is done because in case if search or seizure is required, that is done by the police officers also. So in case of section 92 is applicable in case of which articles or parcels or documents which are in custody of postal or telegraph department only. So you can say 92 is an extension of section 91, which is completing the requirement which was related to postal and telegraph department. By this, we complete the part A of the section chapter 7, which is summons to produce. Now we enter into part B of chapter 7. Part B of chapter 7 is related to search and warrants. So now this is related to search warrant. So by the plain reading of the section first, the court, point 1, the court, where any court has reasons to believe that a person to whom a summon or order under section 91 or request under subsection 1 of section 92. So everybody, including the postal and telegraph, which is covered in 91-92, has been or might be addressed will not or would not produce the document or things as required by such summon and requisition, or where such document or things is not known to be to the court to be in possession of any person, or where the court considers that the purpose of any inquiry, trial, or other proceeding under this court will be served by a general search or inspection, it may issue a search warrant, and the person to whom such warrant is directed may search or inspect in accordance therewith and provisions hereafter contained. Point 2. The court may, if it thinks fit, specify in the warrant the particular place or part thereof to which only the search or inspection shall extend, and the person charged with the execution of such warrant shall then search or inspect only that place or part of to be specified. And part 3 says, nothing contained in the section shall authorize any magistrate other than the district magistrate or CJM to grant a warrant to search for a document, parcel, or other things in the custody of postal or telegraph authority. Now, this is a execution part in case if the court believes that the person, whether a common person or a person who is an officer of the telegraph and the postal department or the department itself, who will be addressed by the summons in 91-92, will not or would not, वो करेगा नहीं किसी भी तरह से आपके सामने डॉक्यूमेंट प्रोड्यूस नहीं करेगा by such summon or request से, तो in that case requisition means the order of the police officer in section 91. So in this case the ऐसे केस में या फिर अगर कोर्ट को ऐसा लगता है कि डॉक्यूमेंट हो सकता है आपके पास बट आपको ठीक से मालूम नहीं है कि आपके पास हो सकता है नहीं हो सकता, वो सर्च करके मालूम पड़ेगा हमको. एंड पार्ट सी वेयर द कोर्ट कंसीडर्स पर्पस ऑफ इंक्वायरी ट्रायल, एक जनरल सर्च इंपॉर्टेंट होगा कि शायद कुछ ऐसी चीजें डिस्कवर हो जाए जो हमारे काम में होगी. तो इस सब सिचुएशन में वो सर्च वारंट का लाइट इंडिकेशन कहाँ पे है? इट इज लाइटली इंडिकेटेड इन सेक्शन 92 where 92 2 we talked about with the order of these people, the police will do a search. This is what the order, this is the search warrant which will be executed to, uh, directed to such officer to do the search. Now, if the search warrant is issued, the warrant, if the court feels it is okay to put that, normally they do that, they will put the particular of what, क्या ढूंढना है, and with is clear instructions and कितने जगह पे और कौन सी जगहों पे ढूंढना है उसको, या अगर किसी एक पर्टिकुलर एरिया में चेक करना है तो कितने स्पेसिफाइड पार्ट में चेक करना है, फॉर दैट पार्ट द कोर्ट विल ऑर्डर. Part 3 is only talking about the final limitation on authority, which is a any magistrate. So nothing contained in this section shall authorize any magistrate other than the district magistrate or CGM. So district magistrate और CGM के अलावा कोई भी ये वारंट इशू नहीं कर सकता है. So if we talk about detailed breakdown of section 93, so authority to issue such warrant is of, there are conditions for issuance. So what are the conditions for issuance of authority to issue search warrant? Is non-compliance with summon or requisition. अगर नहीं किया या believed that it will not be complied with. Unidentified position. Maybe there is a position which might be there, which is a speculation, but the court believes strongly it is not produced or not known that the person might have. And general search and inspection. वैसे ही check करेंगे to find some evidence which might be of some use. So ऐसा warrant उस situation में, these are the conditions for the issuance. Execution of the warrant, the individual authorized under the warrant will consider a search or inspection to uncover the required document or materials, whatever it is. Specifications is issued in this particular, mentioned in this particular section. This has got a limited scope. There is not an unlimited scope of search warrant. एक unlimited scope नहीं देते आपको search करने के लिए. Subsection 2 limit करता है कि the court may put what exactly and where exactly and up to how much extent you can go and explore. And last thing is directed to compliance. The person executing such particular warrant is bound to adhere to this particular specificities. Now, limitation and authority is given that in the case of postal telegraph authority, only and only the district magistrate or the CJM can put a warrant for search. The purpose is to enable evidence gathering, judicial oversight, and safeguarding privacy. So this is about section 93. So it is an extension of section 91, 92. In case if 91, 92, the warrant, the summon and the order has been issued, and there is a possibility the person is not uh, surrendering those documents, or there might be a situation where the person is having or not, that's an speculation, or there is a chance, there is a situation where court believes maybe some general search and finding will unearth some kind of evidence. So in all the such situations, to unearth such a document or a particular material, such a search warrant is issued only by the district magistrate or the judicial magistrate. Section 94. Search of place suspected to contain stolen property, forged document, etc. Now, this is a very specifically talking about when a search of a place suspected to contain stolen property, जहाँ चोरी का सामान रखा हो या forged document, नकली जाली डॉक्यूमेंट रखी हो, ऐसी जगहों पे सर्च का कैसे करेंगे? तो if a district magistrate, an SDM, or magistrate of the first class, which is JMFC, upon information and after such inquiry, as he thinks necessary, has reasons to believe that any place is used for sale, deposit or sale of stolen property, or for the deposit, sale or production of any objectionable article to which this section applies, or that any objectionable article is deposited in any place, he may be by warrant authorize any police officer above the rank of a constable to enter with such assistance as may be required such place, to search the same in the manner specified in the warrant, and to take possession of any property or article therein found which he reasonable suspects to be stolen property or objectionable article to which this section applies, and to convey such property or article before a magistrate or to guard the same on the spot until the offender is taken before the magistrate, or otherwise to dispose of it in some place of safety, to take into custody and carry before a magistrate every person found in such place who appears to have been privy to the deposit, sale of production of any such property or article, knowing or having reasonable cause to suspect it to be stolen property, or the case may be objectionable article to which the section applies. The objectionable article to which section applies. Now, this section is about search of place of suspected stolen property, forged document, etc. But it always says टू द आर्टिकल्स विच द सेक्शन अप्लाइज, कौन सी चीजों पे ये सेक्शन अप्लाई होता है, उन्हीं चीजों के सर्च एंड प्रेजेंटेशन के लिए ये सेक्शन एप्लीकेबल है. एंड द लिस्टेड आर्टिकल्स आर काउंटरफिट कॉइन, नकली सिक्के, नकली नोट, पीस ऑफ मेटल मेड इन कॉन्ट्रावेंशन टू द मेटल टोकन्स एक्ट और ब्रॉट इन टू इंडिया कन्वेंशन ऑफ in contravention of any notification for the timing, नकली नोट, फॉरेन करेंसीज, टूटे हुए सिक्के, नकली सिक्के, काउंटरफिट नोट, काउंटरफिट स्टैम्प्स, forged document, false seal हो, obscene object, which is part of section 292, एंड इंस्ट्रूमेंट और मटेरियल यूज टू प्रोडक्शन ऑफ, ऐसी सारी चीजें जो प्रिंट और बना सकती है ऐसे सिक्के और नोट को. ये है इस आर्टिकल के articles on which this article is applied, this section is applied. Now, coming back to the section, this section, if is applicable, initiated by who has the power authority, district magistrate, SDM, and magistrate of the first class. Why it has been given to district magistrates, SDM, and magistrate? Because these things might be uh, a subject of inspection or awareness of the executive magistrate as well as the judicial magistrate. Why judicial magistrate is only not only there? Because judicial magistrate is somebody who is only available and aware of things which is produced in front of him. Suo motu cognizance is not always possible in case of a magistrate. So, but executive magistrates are the people who are working in this direction. They are the administrators. वो administrators हैं, वो इस एरिया में काम करते हैं. For these areas of counterfeit note and all those things, that is their responsibility to stop. And that is why their head of their executive magistrate, which is the district magistrate, and the SDM, which reports immediately to him, to work in under various subdivision, इन दोनों को पावर दिया गया है. दैट इज वाई द सब डिविजनल एसडीएम एंड द डीएम हैज बीन गिवन अ पावर अंडर दिस एक्ट and not only the judicial magistrate. That is the reason, because they are already working in that area. Now, upon information, after such inquiry, as he thinks, believe कि ऐसी जगह पे कोई चोरी की चीजें या ऐसी चीजें जो ऑब्जेक्शनेबल है या तो बेची जा रही है या रखी जा रही है, ऐसी जगहों पे ऑब्जेक्शनेबल चीजें भी रखी गई हों, तो ऑथराइज कर सकता है किसी भी पुलिस ऑफिसर को जो कि कांस्टेबल या उसके रैंक से अबव हो, किसी को भी ऑथराइज कर सकता है. दैट इज अ पावर टू हिम. नाउ ये पावर है ऑथराइज करने का, तो ऑथराइज करने के बाद वो कांस्टेबल और एनी ऑफिसर अबव द रैंक ऑफ कांस्टेबल पुलिस के, उनका क्या काम होगा ये सेक्शन में जब ये हाथ में इनके वारंट आएगा तो. सो टू एंटर विथ सच असिस्टेंस एज मे बी रिक्वायर्ड. अब एंटर करने का उनको अधिकार है उस जगह पे जहाँ पे उनको ऑर्डर मिला है जाने का और सर्च करने का. प्लीज रिमेंबर सेक्शन 47 ऑल्सो इन दिस रिगार्ड, जहाँ पे आप फोर्सिबली एंटर कर सकते हैं, आप खिड़की दरवाजे तोड़ सकते हैं, वो सब चीज़ें आगे आएंगी, एप्लीकेबल है. टू सर्च द सेम इन मैनर स्पेसिफाइड इन द वारंट, वारंट में जैसा लिखा है वैसा आपको उसको सर्च करना है. तो ये दो चीज़ें वो करेंगे. अभी चीजें जब आपके पास आ जाती है तो आपको क्या करना है, आपको उन चीजों का पोजीशन लेना है. सो दे विल टेक अ पोजीशन ऑफ दिस प्रॉपर्टी विच दे थिंक कि चोरी का है, ऑब्जेक्शनेबल है, ताकि वो मजिस्ट्रेट के सामने पहुंचा सके. बट टू कन्वे सच प्रॉपर्टी और आर्टिकल बिफोर मजिस्ट्रेट और टू गार्ड द सेम ऑन द स्पॉट. अब एक हाथी चोरी हो जाता है तो हाथी लेके मजिस्ट्रेट के पास जाएंगे नहीं. अगर कोई बड़ा सा ट्रक चोरी हो जाता है या कोई बहुत बड़ी सी चीज चोरी हो जाती है, पेड़ चोरी हो जाता है चंदन का, तो आप वो मजिस्ट्रेट के पास लेके जा नहीं सकते हैं. तो वहां पे आप गार्ड करेंगे ऑन द स्पॉट उन चीजों को अंडर सेक्शन डी. एंड ऑफेंडर को लेके जाएंगे फिर आप मजिस्ट्रेट के पास. मे बी आप पिक्चर्स कलेक्ट करेंगे, आप पंचनामा करेंगे, आप लिस्ट ऑफ ऑब्जेक्ट बनाएंगे. हाँ, बट अदरवाइज आप वो चीज़ों को गार्ड करेंगे वहां पे. एंड और अदरवाइज टू डिस्पोज ऑफ इट इन सम प्लेस ऑफ सेफ्टी. अगर ऐसी चीज़ें हैं जिसको डिस्पोज कर देना चाहिए, आप वो रख नहीं सकते हैं, तो आप उसको सेफली डिस्पोज कर देंगे. टू टेक इन टू कस्टडी एंड कैरी बिफोर अ मजिस्ट्रेट एवरी पर्सन फाउंड इन सच प्लेस. पॉइंट ई सेज, सबसेक्शन 1 ई सेज अभी ये सारी चीजें हो गई, आपने उस जगह पे एंटर किया, सर्च किया, आपने उस प्रॉपर्टी को फाइंड किया, उन चीजों को जो आपको रीजनेबली बिलीव होता है चोरी का सामान हो सकता है। हाँ, उसके बाद आपने अगर वो चीज ले जा सकते हैं, ले जा सकते हैं तो ले गए आप उनको दिखाने के लिए। अदरवाइज आप वहाँ गार्ड करेंगे और उस बंदे को, जो बंदा, द पर्सन हु हैज डन दैट पर्टिकुलर, और द पीपल हु हैव डन दैट काइंड ऑफ crime to execute that deposit or sale, you will take them to the magistrate, and that is there, that is why you will that is how you act under this particular section. And objectionable article are so and so. Now if we go ahead and do a postmortem of section 94, so section 94, the search of place suspected to contain stolen property and objectionable article, ऐसी जगह जहां सर्च करने का परमिशन मिला है आपको अंडर दिस सेक्शन टू सर्च एंड find any stolen property or objectionable article. Objectionable article could be anything which is a counterfeit coin, etc., etc., or maybe anything which is listed in this particular section under subsection 2A to G. So authority to issue such warrant is only to the executive magistrate heads, which is DM and the SDM, and the JMFC. So these are the only people who are allowed to do this. Now, authorization granted in the warrant is of what kind of authorization is given to enter and assist. So any kind of entrance which is required can be done under this order, एंड विथ एनी असिस्टेंस विच इज रिक्वायर्ड। आपको जो भी असिस्टेंस लगेगा उसके अंदर जाने के लिए, अगर आपको ताला तोड़ने के लिए आदमी चाहिए तो वो आप ले सकते हैं, अगर आपको उस दौड़ को तोड़ के गिरा देने के लिए चाहिए तो चार्ज कर सकते हैं। एंड वॉट एवर इट इज, इफ देर आर पीपल हु विल रेजिस्ट, यू विल ब्रिंग इन सम मोर पीपल टू कंपेल दैट पर्टिकुलर टू लेट यू गो इन। वो सारी चीजें आप कर सकते हो। वन लाइन सेज टू एंटर विथ सच असिस्टेंस एज मे बी रिक्वायर्ड, जितना रिक्वायर्ड हो, ऐसा नहीं आप गोली मार करके किसी को गिरा देंगे। No, because for such environment. So the balance of law happens in both the places. That's why the words are very, very important in the clear writing, reading of the words in the sections. So assistance as may be required. It looks a very simple thing. As may be required. एक simple English नहीं. As may be required balances both. Less amount of power which you are using, that is also questionable. आप जा सकते थे, आप ताला तोड़कर बरामद कर सकते थे, आपने किया नहीं, आप लौट कर चले आए, तब बाद में वो चीजें अपने हाथ से चली गई, देन दैट पर्सन, दैट पुलिस माइंड हैव डन समथिंग रॉन्ग, और उसको फाइन होगा उस चीज की, या पनिशमेंट होगी। या फिर आपने कुछ ज्यादा ही ताकत लगा दी, आपने वहां पर एक बॉम्ब लगा दिया उड़ाने के लिए, जिससे कई लोगों को चोट लगी, प्रॉपर्टी डैमेज हो गया, या फिर आपने किसी को गोली मार दी जो आपको रोक रहा था। तो इट इज एज मे बी रिक्वायर्ड इज अ right quantum of assistance what is required for you to go inside. And so first power which is given to is to enter, to search, then to seize, and then conveyance of the seized. So then you convey the seized material. To guard is also is within the perspective of conveyance in this meaning of this law. कन्वेंस के अंदर ही आ जाता है, क्योंकि कन्वेंस कर पाएंगे या फिर बाद में कन्वेंस करेंगे, यू गार्ड इट एट दैट पॉइंट ऑफ टाइम। एंड देन कस्टडी ऑफ द पर्सन, जो लोग हैं उनको आप जो रीजनेबली उसमें आपको लगता है संलग्न है, मिले हुए हैं, ऐसे लोगों को हु आर रिस्पॉन्सिबल, हु माइट बी कनेक्टेड और समहाउ दे आर रिलेटेड टू दिस, इफ यू रीजनेबली बिलीव, all those people have to be produced to the magistrate who has ordered. So this is one thing. Now, objectionable articles is a very important part. Under this section, you could only uh, issue and warrant against only those things which are listed from section 2A to G. So what is the importance of this section 94? If somebody says the important is it empowers the law enforcement. So law can be enforced. If required, the things could be recovered. Protection of public interest. So it helps the public interest protection as well, because if things which are believed to be stolen are stored there, if say for example 50-60 mobile phones are stored there, 50 मोबाइल फोन वहां स्टोर्ड हैं, वो 50 मोबाइल फोन आपको बरामद करना है, इट्स इंटरेस्ट ऑफ द पब्लिक ऑल्सो। प्रिवेंटिंग क्रिमिनल एक्टिविटी, आपको अधिकार यहाँ तक दिया है कि आप जो भी इस्तेमाल कर सकते हैं पावर जो रीजनेबल है, आप अंदर जाकर के बरामद करके अरेस्ट कर सकते हैं, तो क्रिमिनल एक्टिविटी उससे कंट्रोल होती है। And judicial oversight is attached to it from start, that only the magistrate so and so can do it. So Section 94 is a very important one in terms of if there is a belief of stolen property and forged document to present and in some premises or in control of some people. Section 95, power to declare certain publications forfeited and to issue such warrants for the same. Abhi, there are many such examples in the history of law where certain publications were considered obscene or anti-national or some contents which might be instigating, for example, related to Naxal activities. So all those, it's been historically has been, there is a notice which has been issued and that particular thing is forfeited. So we talk about it step by step once we go to the further sections, but we talk about the documents which are publications which are considered in such sections in such way to be eligible for a forfeiture and how the power to declare such publication for to be forfeited. So declaration is first part of this section and to issue search warrant for the same. So once you have a power and procedure to declare this publication is to be forfeited and to issue search warrants for the same. So in case if you believe that is hidden, some literature, some content is hidden somewhere or somebody is hiding that, you need to have a search warrant to uh, recover that also. Why search warrants are so important? Because until and unless there is a procedure of search warrant, of course, there are procedures where without search warrant also, if there is a very strong belief, a police officer or a judicial magistrate or a common person also believes there is a something which is hidden in the plain sight and which might be something which is unlawful, the person in his or her power either has in the jurisdiction, they have powers to go ahead and recover those things without any warrant also and produce it to the nearby police station or the officer. Or in case the common person may report it to the right authorities. But the in general, such warrant is very, very important because it gives a standard procedure. When you have a such warrant in your hand and we are doing a search warrant based um, search, then number one, you are the one who is allowed by the court. There is a judicial oversight. Then there is an extent of search. आप उतना ही सर्च करेंगे जितना आपको बोला गया है. And then there is a again second extent of search, second level where आपको क्या सर्च करना उतना ही सर्च करेंगे. तो ये सारी चीजें कंट्रोल करती हैं टू कंट्रोल द एप्लीकेशन ऑफ लॉ प्रॉपरली विदाउट क्रिएटिंग एनी न्यूसेंस और misuse of power. So in coming back to section 95, power to declare certain publication forfeited. So first power to declare and then to issue such warrant. So where any newspaper or book or any document, so anything which is written, publication, wherever printed, appears to the state government to contain any matter that publication of which is punishable under 124A, 153A, 153B, and or section 292 or section 293 और section 295A of IPC. अब याद रखें ये जो लॉज है ये ब्रिटिश के जमाने से चले आ रहे हैं. दैट इज वाई these things were very very important for British also at that point of time. Now, what are these sections? Which sections we are talking about? 124 is talking about sedition. So anything which is against the government. 153 is about promotion of enmity between different group. दो लोगों को झगड़ा हो जाए ऐसे चीजें आपने पब्लिश की है दो ग्रुप का. 153B is imputations, assertions, प्रीजुडिशियल और नेशनल इंटीग्रेशन से रिलेटेड, देश की इंटीग्रेशन इंटीग्रिटी से रिलेटेड अगेंस्ट आपने कुछ ऐसा करने का कोशिश की क्राइम लिटरेचर के थ्रू. 292 सेल ऑफ ऑब्सीन बुक्स, अश्लील किताबें बेच रहे हैं. 293 सेल ऑफ ऑब्सीन ऑब्जेक्ट्स टू यंग पर्सन, आप यंग लोगों को बेच रहे हैं. एंड 295 ए टॉक्स अबाउट डिलिबरेट एंड मैलिशियस एक्ट इंटेंडेड टू आउटरेज रिलीजियस फीलिंग, किसी की धार्मिक भावना को ठेस पहुंचा रहे हैं. तो ऐसी किसी भी चीज से, so wherever printed appears to state government to contain in matter publication which is punishable under so and so sections, the state government may by notification stating the ground of its opinion declare every copy of the issue of this particular newspaper containing such matter and every copy of such book or document to be forfeited to government. The and thereupon any police officer may seize the same wherever found in India, and any magistrate may be may by warrant authorize any police officer not below the rank of sub-inspector to enter upon and search for the same in any premises wherein a copy of such issue और एनी सच बुक और डॉक्यूमेंट मे बी रीजनेबल सस्पेक्टेड टू बी। सो अभी ये सारे सेक्शंस के अंदर में जो भी चीजें अगर लगता है स्टेट गवर्नमेंट को है, वो स्टेट गवर्नमेंट ऑर्डर कर सकती है टू ब्रिंग इट टू देमसेल्फ, गवर्नमेंट के पास जमा करना है, जिसके अंदर में कोई भी पुलिस ऑफिसर विच इज एट द रैंक ऑफ नॉट लेस देन सब इंस्पेक्टर से नीचे नहीं हो, ऐसे पुलिस ऑफिसर को वारंट इशू किया जा सकता है इसको एग्जीक्यूट करने के लिए बाई एनी मैजिस्ट्रेट एंड टू फाइंड इन एनी प्लेस इन इंडिया, either it's a book, a newspaper issue, or whatever document it is. Now, in this section and section 96, newspaper and book have the same meaning as in the Press and Registration of Books Act. Document includes any painting, drawing, or photograph or other visible representation, and past, no order passed or action taken under this section shall be called in question in any court otherwise than in accordance with provision of section 96. So 95 and 96 are connected sections. 95 talks about the power to declare certain publication to forfeited, power क्या है, और search warrant issue करने का power है. While when we come to 96, which is talking about setting aside the publication being called as forfeitable. So ये दोनों सेक्शन जो है एक दूसरे के साथ कनेक्टेड है, both are connected. And for this section 95 and of course 96, the books, newspapers, etc., whichever is printed in the under Press and Registration of Book Act, which are registered, those are called newspaper and books, and document could be anything else apart from that, anything else. And no order passed or action taken under this section shall be called in question in any court. Otherwise, then procedure of 96. So if you want to call out against this forfeiture of document, maybe for some reason, there are very famous cases, I leave it to you to find it. Those in those matters, obscene materials being sold on the street were forfeited by the government, but then the matter went up to the Supreme Court, and the Supreme Court came back and provided a judgment saying, no, there is a content which is specifically made for adults, and such contents are required for the entertainment of the adults, cannot be considered forfeitable, and those magazines and books were then allowed to be sold. So if we talk about section 95, the types of publication is clearly given as per the plain reading of the sections written here. And the ground of opinion that is also connected with those sections. For example, section 124 is sedition. If sedition is being committed, the crime of sedition is being committed by those newspaper and magazines or books or documents, then of course for the reason of ground of a particular forfeiture is anti-sedition, promotion of enmity, or selling of obscene books, all those things relevant to the sections. These are the grounds of particular warrant to be issued and the publication be called forfeitable. So newspaper and book and documents are defined under this section, which is applicable for section 96 as well. Now let's go to section 96, where any person having any interest in any newspaper, book or other document in respect of which a declaration of forfeiture has been made or under section 95 may within 2 months from the date of publication in the official gazette. So whenever the forfeiture is applicable and called to be applicable on particular publication by the state government talks with the GRs. So GR will have official gazette will have a publication where it will come back and say so and so date the government notifies to public in general and to all the relevant departments that this particular publication is considered forfeiture. For everything there is an official gazette. You create a new university, that university is listed in the list of the state government, that is also coming under the official gazette. So for that sake, anything which is declared by the state government is always published in the official gazette of the such declaration. So in that case, within the 2 months from the date of publication in the official gazette of such declaration, the person has to apply to where? Apply to High Court to set aside such declaration. So no other court, the person has to reach out to High Court on the ground that so and so material in respect to which declaration was made does not contain any such matter. So I was the story which I told you about the magazine, the very same process. The person who might have seen on the street and might have gone back and made a request to the application to the state government, and the government might have come back and said, okay, we forfeit it. Or certain content, certain magazines, certain poetry, certain stories, if are considered that way, that is also something which is added in the official gazette of the government, and warrants were issued to forfeit everything, each and every copy, and give it back to the forfeit to the government. So the person may be the who is the publisher, or maybe the person who has bought the publication right or circulating it, the circulator. So either of the parties will come back and file a declaration to setting it aside. Now, every such application shall, where the High Court consists of three or more judges to be heard. Now, why three or more judges is added in such scenarios? Because these are sensitive and complicated issues where there might be difference of opinion, and to safeguard that, it is always advised to have three or more judges and in odd numbers to be heard and determined by special bench of High Court composed of three judges, and where the High Court consists of less than three judges, such special bench shall be composed of all the judges of the High Court. So either you have three judges, or create a special bench which is composed of all the judges of the High Court. Why? Because the rule of uh, the maximum uh, vote will be applied. So, on the hearing of any such application with reference to any newspaper, any copy of such newspaper will be given in evidence in aid of the proof of the nature. So, आप वो document देंगे, and tendency of the word sign of visible representation contains such newspaper in respect of which the declaration for. So, you will bring the material first of all. The High Court shall, if it's not satisfied, the issue of newspaper or the book or other document in respect of which the application has been made contain any such matter referred to section 1 of section 95, set aside the declaration of forfeiture. Where there is a difference of opinion among the judges, the special bench, the decision shall be in accordance with the opinion of majority of those judges. So why more than three and more? Because with two judges you cannot have a opinion majority to be declared. मेजोरिटी आप जजेस का नंबर जब तक तीन नहीं होगा, आप मेजोरिटी माइनॉरिटी डिक्लेयर नहीं कर सकते. यू हैव टू वन, वन टू. इफ यू हैव टू जजेस, हाउ वुड यू डू मेजोरिटी? सो ऐसे केसेस में या तो तीन जजेस का बेंच होगा, या स्पेशल बेंच विच इज कंप्राइज ऑफ ऑल द जजेस ऑफ द हाई कोर्ट, और वो मटेरियल को इंस्पेक्ट करेंगे. इंस्पेक्ट करने के बाद अगर वो सेटिस्फाइड नहीं है विद दिस पर्टिकुलर थिंग टू बी फॉरफिटेबल, दे कैन कम बैक एंड डिक्लेयर this is not a forfeit, for the declaration is set aside. Or if there is a difference of opinion, a majority opinion is taken. So that is how this particular uh, appeal works for in the case of you believe the declaration of forfeiture has to be set aside. Now, if we go and do dissect this particular section again, as we do all for all the sections, why for what is the importance of this particular section is, it's a mechanism in case if you are aggravated by a declaration of forfeiture. So there is an option given to you in the just in the for the justice for the for you to go and apply and challenge it. So something which is a right to apply. The eligibility is only given to the people who are interested, who has got an interest, not a third party who has no interest in the particular document or magazine or newspaper can go and do it. So there is an eligibility. Then there is a time limitation that if you want to challenge, you challenge within 2 months of publication in the government gazette, where it is considered a forfeiture is declared there. Composition is of special bench. Either you have three bench or you have all the judges from the bench, and then you look into the majority. And evidence is the actual content in the document which has to be evidenced. And the judicial evaluation then happens and the majority decision is considered. So what it encompasses, Section 96, is it helps in protection of the rights, because if somehow it is believed to be something to be forfeited, it is not done just blindly. You have an opportunity to come back and challenge it. There is a judicial oversight and accountability which is added there. It is fairness which is enabled through this section, and encourage accountability in authorities. Now, we have been talking about the search and warrant of articles. Now, Section 97 talk about search of persons wrongfully confined. Now, if somebody is confined wrongfully, so if any district magistrates, SDM, or magistrate of the first class has reasons to believe that any person is confined under such circumstances that the confinement amount to be an offense, he may issue a search warrant, and the person to whom such search warrant is directed may search the person so confined, and such search shall be made in accordance therewith, and the person, if found, shall be immediately taken before the magistrate, who shall make such order as in the circumstances of the case seems proper. So, if a person is believed to be wrongly confined, किसी को किसी ने पकड़ कर रख लिया, in that case, again, district magistrate, SDM or magistrate. Why additional to the JMFC, SDM and DM is added? For the same reason, because they are the people who are managing the law and order of the city, and they might come across such a situation where they might come across a situation or news of such thing happening, and in that case, being an administrator also, they are allowed to put a search warrant and put such directions about whom, where, and how the search has to be made. And the person, if search, when the search is carried out, if the person is found in accordance to the warrant, it is brought back to the same magistrate who has issued the search warrant. So, authority to issue such warrant is only given to the empowered magistrates, the district magistrate, SDM, and the JMFC. It is only against a circumstance where they believe strongly a person is confined wrongfully. The power of the warrant which is given is about search for the confined individual, उनको ढूंढने के लिए है, और immediate action, और उनको उनको निकाल कर ला करके मजिस्ट्रेट के सामने प्रेजेंट करने के लिए है. Magistrate subsequent action is that the magistrate will make an order in circumstances of the case. So whatever is relevant, जो सही होगा magistrate वो आदमी को उसके सामने लाने के बाद that magistrate will make a relevant order. So this 97 talks about protection of personal liberty, judicial oversight in the whole activity, immediate intervention, and legal framework for accountability, so that it enables to act responsibly and lawfully. Nobody can just go and search directly. It has to be empowered by a court to go ahead and do that. Similar lines, power to compel restoration of abducted females. So, upon complaint made on oath of the abduction or unlawful detention of a woman, complaint made on oath, or a female child under the age of 18 years for any unlawful purpose, a DM, SDM, or JMFC may make an order for the immediate restoration of such women to her liberty, or such female child to her husband, parent, guardian, or other person having the lawful charge, or such child may compel compliance with such order using such force as may be necessary. Now, important things, upon complaint made on oath of the abduction or unlawful detention. So, abduct कर लिया किसी ने, या अनलॉफुली पकड़ कर रख लिया एक वुमन को या एक फीमेल चाइल्ड को, विच इज द सब्जेक्ट ऑफ दिस सेक्शन, और जो फीमेल चाइल्ड अंडर 18 हो. एक्चुअली अगर 18 के पहले का बच्चा हो, 18 के बाद का भी हो, इट कवर्स एक्चुअली एवरीथिंग. Frankly speaking, if you say it is a woman or a female child under 18, covers since born to since died, up to died. सो फॉर एन अनलॉफुल पर्पस, किसी अनलॉफुल पर्पस से किसी ने पकड़ के रखा हो, तो ये सारे मैजिस्ट्रेट ऑर्डर कर सकते हैं इमीडिएटली रिस्टोरेशन, बट द कंप्लेंट हैज टू मेड ऑन ओथ. व्हाई इट हैज टू मेड ऑन ओथ? Because oath then gives a verification clause, and it says whatever I'm saying is correct. So that gives a guarantee that the complaint which is made responsibly, and the person takes a responsibility that he or she confirms this is true, and if it is not true, they are responsible for the consequences of making a false application. So that security is also aligned so that nobody can just come and make a application just like that. These are sensitive issues, and to make it far more responsible and accountable on part of the complainant also, it is always made on oath. So the so and so magistrate will make an order for immediate restoration. They will ask for immediate restoration of such women or child, either to free them, उसको पकड़ के लिबर्टी मतलब फ्री कर देना है, और उनको उसके हस्बैंड, पेरेंट, गार्डियन या किसी के पास जिसके पास लॉफुली उसको दे सकते हैं, दे देंगे, एंड मे कंपेल कंप्लायंस विद सच ऑर्डर यूजिंग सच फोर्स एज बी नेसेसरी। और इसको करने के लिए अगर नेसेसरी फोर्स, जो मैंने पहले सेक्शन में बताया था, इट हैज टू बी अ नेसेसरी फोर्स विच इज रिक्वायर्ड कैन बी अप्लाइड, वो कुछ भी हो सकता है, रीजनेबली वॉट एवर इज रिक्वायर्ड टू कंपेल द compliance with such order. So if we dissect this order, this section, it says ground for action. So ground for action is complaint made on oath. So it has to be made on oath. So it cannot be done for unlawful purpose. कोई इसलिए नहीं करेगा कि कहीं उसे ढूंढ के लाना और कहीं पकड़ कर मंगवाना है पुलिस के यूज से. By oath, if you do, it's only lawful purpose you will do it. Authority of the magistrate is given to certain specific magistrates only, and immediate restoration is added. So if this order is issued, it cannot be kept on hold for a day, half a day, or something. Immediate execution happens after immediate order. So order has to be made and the immediate restoration. So immediate action on the order has to happen, and it does the compelling, the compliance, and whatever necessary force is required, which can be utilized in this section as well. And protection of vulnerable individuals. So these are vulnerable individuals considered, the female or of any category from between below 18 years or above 18 years, and their safety is guaranteed by this section. And this is judicially accessible. So judicial intervention and accessibility is there, and encouragement of reporting. So in case of this, there is an order which is issued with a warrant which is issued, and if the person is compelled to comply with the compliance, similarly the person who is executing the warrant also will also make a report, and that is why a record of such incident end to end is also created. Now we enter to the part C of this particular chapter. Part C is about general provision related to searches. So we talk about general provisions about searches. Now, direction, etc. of search warrant. The provisions of section 38, 70, 72, 74, 77, 78, and 79 shall, so as may be applicable to all such warrants issued under section 93, section 94, 95 और 97. So 93, 94, 97 के जो sections है, उसमें ये सारे sections जो है आपके sections 38, 70, 72, 74, 78, 79 अप्लाई होंगे. सेक्शन 93, 94, 95 और 97, ये जो सारे सेक्शंस हैं, जो जो भी इस जो इनके अंदर जो भी सर्च वारंट इशू होंगे. सो 93 के अंदर जो सर्च वारंट इशू हुए थे कौन से थे? 93 में सर्च वारंट रिलेटेड टू प्रोड्यूसिंग डॉक्यूमेंट और अदर आइटम. 94 था स्टोलन प्रॉपर्टी और अदर ऑब्जेक्शनबल आइटम. 95 प्रोक्लेमेशन एंड फॉरफीचर ऑफ पब्लिकेशन डीम्ड हार्मफुल. और 97 सर्च फॉर रॉन्गफुल कन्फाइनमेंट ऑफ इंडिविजुअल्स. ये सारे सेक्शंस के अंदर जो सेक्शंस होते हैं, इसके अंदर जो सर्च वारंट इशू होते हैं, वो अप्लाई होंगे कौन से सेक्शन के? सेक्शन 38 डील्स विद द पावर रिगार्डिंग द इशू ऑफ सर्च वारंट अंडर स्पेसिफिक सर्कमस्टांसेस. सेक्शन 70 के प्रोविजंस इंक्लूडेड होंगे, विच इज concerns who a warrant can be directed to and the authority required to execute it. Section 72 is related to provide stipulation about multiple officers executing a warrant. We have read about that, right? When it has to be delegated to whom, multiple officer, who can direct to other person, discuss the ability of one police officer warrant be executed by another person. So it end of the day talks about, through all these inclusions of the sections, it talks about how the such warrants will be issued and how it will be executed by furtherance of execution of this warrant, and what is the mechanism and who can execute. So it's a combined composite section 99, which is applicable to all the search warrants here under 93, 94, 95, 97, and including the provisions which are included in those sections which are mentioned earlier. So it is something which is not being repeated at this instance, but by reference to these sections, it gives a legal clarity and uniformity that we are using the same process here also in the search warrant, what is applied earlier in the previous sections, and it makes an effective legal enforcement. Coming to section 100. So 100 is a person in charge of closed place to allow search. So section 47 you might have remembered. So where we talked about the same thing. It is one of the same thing. It's very similar to that, where we remember we talked about the person is empowered to break door, internal, external. The person is allowed to break a window. The person is allowed to break door. If the person is caught inside that particular premises unlawfully, he can break and come out also. He can ask assistance, and it's a duty of the person who is the owner, supervisor, or somebody is in charge of that place. All those things are applicable. So whenever any place liable to search of inspection under this chapter is closed, any person is deciding in of being in charge of such place shall, or demand on demand of the officer or the person executing the warrant, and on production of the warrant, allow him free ingress thereto to afford. So this is exactly same what we talked earlier. If ingress into such place cannot be obtained, the person can break and enter, which is as section 2 of 47. Where any person in or about such place is reasonably suspected of concealing about this person any article for which search should be made, such person may be searched, and the person is woman is the search shall be made by another woman with strict regard to decency. So if the person inside or about such place is reasonably suspected, now read it very carefully. Where any person in or about such place is reasonably suspected of concealing about his person any article for which search should be made. So if the person who is making concealing about his person any article for which the search should be made, and who is that person? The person inside that premises or about such place. So it's not necessary that person is was present inside the premises also at that point of time. He's somebody who might be related to that also, and very strongly. Such person may be searched. That person can be searched also. And if such person is a woman, of course, maintaining decency, a woman officer has to come back and check. Before making a search under this chapter, the officer or other person about to make it shall call upon two or more independent and respectable inhabitants of the locality, the punch, as we say, in which the place to be searched is situated, or of any other locality if no such inhabitant of said locality. So there is a two independent witness who are of good reputation, respectable people from the locality, or if nobody is there from an outside locality, has to be brought in as witness to the search to attend and witness the search, and may issue an order in writing to them or any of them so do so. So it is made mandatory that if such a search is being considered, you have at least two people there available who are respectable people from the locality or nearby, who could be present during the search operation, and they see what exactly is recovered. So it can be done either by issuing an order in writing or by physically calling them, directly calling them or talking to them also. The search shall be made in their presence, and a list of all things seized in the course of search है, वो list उसके सामने बनाएंगे. That shall be prepared by such officer or the other person and signed by such witness. So witness will sign, okay, this was found in front of me. But no person witnessing a search under this section shall be required to attend the court as a witness of search unless specifically summoned by it. कोर्ट को जब तक नहीं चाहिए तब तक आप ये आने की जरूरत नहीं है कोर्ट में आपको. एंड दिस इज वेरी वेरी इंपॉर्टेंट. लॉट ऑफ केस लॉज इन around that for search and seizure, where there have been discrepancies in the way the things were mentioned in the list of articles which was recovered and how it was perceived by the witness, and exactly what exactly was there in the list. So presumptions of the witness, the list being not very clear, all those things, there are multiple case laws around that. Point 6, the occupant of the place searched or some person in his behalf shall in every instance be permitted to attend during the search, and a copy of the list prepared under this section signed by the said witness shall be delivered to such occupant or person. तो जो भी occupant है उस place का उसको एक copy देंगे signed. When any person is searched under subsection 3, हमने ऊपर बात की थी, in the person in or about such place, a list of all things taken possession of shall be prepared and copy thereof shall be delivered to such person. उस बंदे को एक copy भी देंगे. Any person who without reasonable cause refuses or neglects to attend and witness a search under this section when called upon to do so by an order in writing delivered or tendered to him shall be deemed to have committed an offense under 187 of Indian Penal Code. So we saw that person could be in subsection 4, the person could be ordered or in writing to come and attend, and if the person is not coming, it is a crime offense against section 187, which is the provision to have an importance of cooperating in legal investigation, and the person is accountable if the person puts an hindrance to such process. So any person who puts an hindrance to such process under section 187 is also an offense is committed and is also punishable. So basically, what are the basic ingredients of this section? It's a long section, 100. So it's an obligation to allow search. So whenever this particular search happens, there is an obligation created to the person who is going to allow search. So it's something which is obligation to the person. Now, the person who can demand for an access under this section and reasonable facilities for search, whatever force required. The person can obtain access when denied by reasonable force or reasonable action, whatever required. And suspicious person and women could also be searched in this. The witness is a very key ingredient in the section 100, where a witness, at least minimum two, has to be there, and the witness could be brought into the particular situation either by an order or by a written note, whatever, and the person has to make himself or herself available during the search to be witness. Once ordered and requested to be part of that particular search, the person, until and unless कुछ reasonable नहीं है, they cannot make not themselves present there or be absent. Otherwise, they have committed an offense under section 187 of the Indian Penal Code. The occupant has a special right in this called in section 100, where if this premises is owned by somebody, that person will also get a copy. And if the person, somebody is searched in person, that person will also get a list of things which were recovered from that person. डॉक्यूमेंटेशन जो है ऑफ इंडिविजुअल सर्चेज जो है वो एक लिस्ट ऑफ आइटम में क्रिएट होता है जो विटनेस से साइंड होता है दैट इज ऑल्सो रिक्वायर्ड एंड what is the importance of section 100 in that case? Where does it stand? Is uh, it makes it a lawful search because it's being done under judicial or a magisterial uh, 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 in foresight and insight is also added, and supervision is also there, protecting the individual right also because it specifically says what has to be searched and what not, and judicial accountability automatically is inbuilt. So this makes it a very, very important clause to have a proper search in a closed place for the sake of collecting such evidences. Section 101, disposal of things found in search beyond jurisdiction. So when in the execution of a search warrant at any place beyond the local jurisdiction of the court which issued the same, any of the things for which search is made are found, such things together with the list of the same prepared under the provisions hereinafter contained shall be immediately taken before the court issuing the warrant unless such place is near to the magistrate having jurisdiction therein, that to such court, in which case the list and things shall be immediately taken before such magistrate, and unless there be good cause to the contrary, such magistrate shall make an order authorizing them to be taken to such court. So basically what this is saying is it's a execution of search warrant beyond jurisdiction. So what is the context of execution? It says when a search warrant is executed outside the local jurisdiction of the court, court के local jurisdiction से बाहर है, that issued it, the item related to the search are found. specific steps must be followed regarding the handling of this item, how it is to be handled. Now, once the things are found, it was in the out of the jurisdiction of the court which ordered that in that particular search. So, forwarding that item and the list is the first immediate proceeding, which is the item discovered during the search, as well as a prepared list, which is draft and detailing these items, must be promptly taken before the court that issued the warrant. This requirement maintains a continuity in the judicial process by ensuring that the findings are reported to the appropriate legal authority that authorized that search. Exception to the closer magistrate is given, which means if the location of the search is near to a magistrate having jurisdiction over that area, then to the issuing court, the items and the list should instead be presented to the local magistrate. This flexibility helps streamlining the legal process. Abhi, if you have a search warrant which is issued for some reason in a jurisdiction outside Pune or outside Maharashtra, immediately they will go to the nearby magistrate. Then the magistrate's responsibility is added in this section 101, where it says, unless there is a valid reason not to do so, the magistrate receiving the item and the list of item must authorize that they can be taken to the court that has issued the original warrant. The provision reinforces the importance of oversight from judicial authorities regarding this management and allocation of seizure. Now, this will help to deliver also. So, the local magistrate, if it comes to the original magistrate, well and good. If not, the local magistrate will ensure it is transported until and unless there is a reason not to do so. So, what is the importance of 101? It's a very small section, but very key section is clarity in legal procedure. It gives a very clear procedure. Who, where you do, out of jurisdiction, how you do, whom do you submit the articles and the list of the articles, and what is the role and responsibility? In this case, is of the local magistrate. So continues the judicial oversight, is irrespective of the distance and the jurisdiction, and it facilitates the effective law enforcement in that case and protections of the right of the people, because the articles might be belonging to somebody and it has to be in safe hands. Section 102, power of police officer to seize certain property. Now, any police officer may seize a property which may be alleged or suspected to have been stolen, or which may be found under circumstances which create suspicion of commission of any offense. I told you at the start, they can do it without a warrant also. Such police officers, if subordinate to the officer in charge of a police station, shall forthwith report the seizure of that officer. So that police officer will report that seizure report to the police officer in charge of the police station. Now, every police officer acting under subsection 1 shall forthwith report the seizure to the magistrate having jurisdiction and where the property seized is such that it cannot be conveniently transported to the court, or where there is difficulty in securing proper accommodation for the custody of such property, or where the continued retention of the property in police custody may not be considered necessary for the purpose of investigation, he may give custody thereof to any person on his execution a bond undertaking to produce the property before the court as and when required, and to give effect to the further order of the court as to disposal of the same, provided that where the property seized under section 1 is subject to speedy and natural decay, and if the person entitled to the possession of such property is unknown or absent, and the value of such property is less than 500 rupees, it may be forthwith be sold by auction under the order of the Secretary of Police, and the provision of section 457, 458 shall nearly as may be practicable apply to the net proceeds of such sale. Now, this particular section not only talks about the power which is given in part 1 about that the officer can, whenever has a suspicion that something is stolen, or maybe in found under circumstances where it might be create some kind of suspicion of any offense, the particular thing the person could seize. They can seize that property. Now, number two talks about the reporting part. So the reporting is mandatory and up to the level of the officer in charge of the police station if the person is not himself the police officer in charge of the police station. But this is only up to the level of the police station. Now it comes to the judiciary, where part 3 talks about that uh, it has to be not only notified and reported within the police station, it has to be notified to the magistrate, because once until and unless it is not notified to the magistrate, the fate of the good will not be decided. It might not be reached logically and legally to the right place. So then point 3 talks about what happens in various scenarios, how it is handled. So in situation where the property cannot be conveniently transported to the court, आप ले ही नहीं जा सकते कोर्ट में इस चीज को, और वे आर सिक्योरिंग प्रॉपर कस्टडी फॉर द पर्पस प्रोसेस, प्रॉपर्टी पोजेस चैलेंजेस, प्रॉपर्टी का प्रॉपर कस्टडी डिफिकल्ट है करना, द पुलिस ऑफिसर में ऑथराइज द प्रॉपर्टी टू गिवन टू अ डेजिग्नेटेड पर्सन. अभी आपको 50 सांप मिलेंगे तो पुलिस स्टेशन में तो रखेंगे नहीं, you will give it to the nearby zoo, or maybe if you got one snake you give to some snake friend. So all those things are required, or some organization taking care of the snakes. So authorize the property given to a designated person. The person may execute a bond undertaking to produce the property in court when required and comply with further court order. तो वो उस आदमी का रिस्पॉन्सिबिलिटी बन जाती है, फिर वो कोर्ट में लेकर आएगा. अगर चीज़ें जल्दी खराब होने वाली है तो इमीडिएटली वो प्रॉपर्टी बेच दी जाएगी, उसकी ऑक्शन कर दी जाएगी, एंड देन अकॉर्डिंग टू सेक्शन 457 450 ऑफ द कोड उसका डिस्पोजल, क्रिमिनल इन्वेस्टिगेशन और मनी मैटर मैनेज किया जाएगा, which will come across once we come to reach 457 458. So this is how the section talks about immediate law enforcement actions around seizing of the objects which they believe to be creating a suspicion of being stolen or part of some kind of commission of the crime. It brings a legal accountability included, where the handling is clearly defined in all the scenarios, and it facilitates the judicial process, because end of the day, by a reporting, it integrates, brings into the magistrate, it brings into the judicial system. So something which was somewhere which was seized has been reported, and then it is definitely connected to the judicial system for a rapid uh, judgment around that, to ensure the fate of the object, such objects. Section 103 says the magistrate may direct search in his presence. Any magistrate may direct a search to be made in his presence of any place for the search of which he is competent to issue a search warrant. Very simple, very straightforward. But what is the meaning? It is an authority of direct sales searches we are talking about. So it's a judicial discretion. So magistrate may give a judicial discretion depending upon applying his mind on the scenario. As a judicial discretion, the magistrate may order that it happens in his presence. So the search has to be conducted in his presence, and that he is competent of. This section says he is competent of issuing such warrant. If he can go ahead and ask to direct such searches in his presence only for the searches which he is competent to issue. So what is the important is extrajudicial oversight, if required, could be applied here. Accountability in law enforcement has happened because of this, and facilitating gathering of evidence if it is very sensitive and the magistrate believes it is going to help, that it happens in front of him, and it promotes a transparency also. And the time is also a factor where he believes that it will be far more easier for him or her to see transparently and in a very rapid way the searches, and to be as being part of it, to understand it better in all the forms. Section 104, power to impound documents produced. Any court may, if thinks fit, impound any document or thing produced before it under this court. So court can impound anything, any document under this code. So authority of the court is something which is mentioned here, but this is again a particular section of judicial discretion. So it is a discretionary power to the judges, to the courts, that if they deem fit, they can impound that. But it is only under the court's consideration. For example, for the purposes of concerned about the authenticity of or relevance of the document, they want to impound and keep the document copy safe with the court. Evidence of tampering, then the court might impound. Necessity to preserve evidence for any upcoming investigation or legal proceeding. Maybe some files, maybe some materials. So all those things could be impounded and by the judicial discretion and by the order of the court. And this gives a physical control to the court. The court is now in a physical control of such things. And it safeguards the evidences in turn. So what is the result end of the day is it is promoting judicial integrity. Judiciary has been empowered with this one liner saying they can, if they want to protect anything by under this section 104. 105 is where a court in the territories to which this code extends thereafter in this section, referred to as the said territories, desired that a summon to an accused person, or a warrant for the arrest of an accused person, or a summon to a person requiring him to attend and produce a document or other thing, or to produce it, or a search warrant issued by it shall be served or executed at any place within the local jurisdiction of a court in any state or area in India outside the said territories. It may send such summon on warrant in duplicate by post or otherwise to presiding officer of that court to be served or executed and someone referred to in clause A or C has to serve the provision of section 68 shall apply in relation to such summons as if the presiding officer of the court is whom it sent where a magistrate in the said territories, and in any courts of place outside India in respect to which arrangements have been made, the central government with the government of such country or place or service or execution of summon warrant in relation to criminal matters thereafter in section they are referred to as the contracting state, if it may send such summons or warrants in duplicate in such form directed to such court judges or magistrate, etc., and to such an authority for transmission as the central government may by notification specify in the behalf. When the court in the said territories has received for service or execution, or they've received a summon or warrant, a summon to any person requiring him to attend any procedure, produce a document, or a search warrant issued, a court in any state or in India outside territories, or a court judge or magistrate in the contracting state, which is contracting state, the state which is making this particular arrangement. I'll show the definition here. Okay, let's first complete this section. So it shall cause the same to be served or executed as if it was summons or warrant received by it from another court in the said territory for service or execution within its local jurisdiction, and where a warrant and arrest has been executed, the person arrested shall so far be possible be dealt within accordance with the procedure prescribed by section 80, 81. A search warrant has to be executed. The things found in such shall be as far as possible dealt with section 101, and provided that in case where a summon or such warrant received from a contracting state has been executed, the documents or things produced or things found in such shall be forwarded in the court issuing the summon or the warrant, or as authority by the central government made by notification, especially in this behalf. Very confusing section. So this talks about couple of things. Listen very carefully. So a reciprocal arrangement regarding the process. Reciprocal arrangements are done with the other countries, other places, which is outside of the jurisdiction. So number one, it talks about the service and execution of summons and warrant. First of all, how the service will happen. So the local jurisdiction and the outside territories are defined. So local jurisdiction and outside territories are defined in this particular section. So within India, if a court within the territories to which the code applies, the in the said territories issues a summon or warrant and desire it to be served or executed as at a location within the local jurisdiction of a court in any other state or areas in India, it may send the document to duplicate by post. Now, we are talking about things to be served within India, but outside of jurisdiction of that particular court. Application of section 68 is mentioned So for summons served under this provision, especially those referred to in clauses A or C, summon or summon by person requiring to attend produce document to these places, the provision of section 68 will apply, which we have read earlier, that the presiding officer of the court receiving the document were to magistrate of the said territories. We read this earlier, right? The ensure that the person summoned is afforded the same right and position as if the situation were handled directly within the issuing court's jurisdiction. So within India, this happens. When we talk about the international jurisdiction, so for any of the summons or warrants that needs to be served or executed in a country outside India, where the central government has established reciprocal arrangement. The first of all, where the central government has already a reciprocal arrangement, and with that foreign government referred to as the contracting state. So they have a relationship. That state is called a contracting state. The Indian court may send such summon or warrant in the appropriate form to a designated authority as specified by the central government. This facility this facilitates the international cooperation in legal matters. So in this case, we are talking about where there is already an arrangement with the country, which is a contracting state, and that has to be sent to the designated authority as is specified. So once you will do a contract with that country, the foreign country government, which is a contracting company, that company already once you have that kind of arrangement, there will be a list of such specific delegated authorities which will also be published, and those have to be followed. When other part talks about when we receive the summons and warrant from the other jurisdiction, then what happens? So local execution, now we are the one who are receiving. So local execution, so if a court in the said territory receives a summon or warrant by a court in any state outside the local jurisdiction in India, a court judge or magistrate in the contracting state means a foreign country. Both situation can happen. First part was talking about when a summon or warrant such thing has to go to either to a court in India which is outside jurisdiction of the issuing court or to a contracting company. Now part 2 we talk about receiving the summons from some territory which is outside my jurisdiction but within the territories of India, or a court judge or magistrate which is from a contracting company where we have a central government based shaking of hands with that company, that country. So the court shall process it for service or execution as it were a summon or warrant from another court within its jurisdiction. So it will treat it as if it is issued by one of the judges in his own jurisdiction. This clause standardizes how external legal processes are treated. So now, I talked about the sending of summons and warrant. In this case, I talk about receiving. So this clause standardizes how external legal processes are treated in both the sides, receiving and sending and receiving. So procedural handling upon execution. So arrest warrant. If a warrant of arrest has been executed, the individual arrested will, as far as possible, be treated according to the procedure prescribed in section 80 and 81 pertaining to the treatment of arrested individual. We talked about 1881, how they have to be treated, how much force has to be put, how much confinement has to be done, how the medical test has to be done, and blah blah blah. So all those things has to be followed. Search warrant if received or sent, the item found during the search must be, as per the provision 101, they have to be handled. So, handling of item from contracting state. Now we have a contracting state where we have an alignment through the central government. So, when a summon or a search warrant from a contracting state has been executed, it has come from those places. Any document or item produced or found during the search shall be forwarded to the issuing court. Now you will execute as if it has been given to you by a same magistrate of the same jurisdiction, and then you will do that particular execution and you will give it back to the issuing authority through the designated authority specified in the government GR by the central government. So this provision ensures proper channels are maintained and proper procedure is maintained in terms of material transfer and evidence transfer or arrest or summon has to be treated cross jurisdiction in India or cross jurisdiction across the countries where we have a friendly contract and those friendly countries are called the contracting state. So, what is the importance of Section 105? It talks about both reciprocal arrangement of receiving summon warrants and uh, sending receive summons and warrants and any person or material to be produced for purpose of evidence, or sending those receiving those requests also from jurisdiction out of jurisdiction places in India or outside India, but purely for the contracting states. The contracting states, which is this is applicable only for those. So it gives an enhanced legal cooperation across India and beyond India. It gives a consistency in legal process because the judge or the court which has been sending the summon and warrant to us will be considered as if it has been sent by our own judges and magistrate in the same jurisdiction. It safeguards the rights and efficient handling of the international matter. But please understand, this is something which is initiated only and only by the central government's execution of such friendliness with those contracting states. And this will help the legal obligations are met across the jurisdiction, cross jurisdiction, and the rights of the individuals are respected. The law is delivered across the border, and the judicial efficiency is increased and enhanced, which is Section 105. So we have completed chapter 7. We're going to chapter 7A now. So it is of chapter 7A is looking from a microscope or a magnifying glass the reciprocal arrangement for assistance in certain matters and produce for attachment and forfeiture of properties, specifically for reciprocal arrangement for assistance in certain matters, certain specific matters, and procedure for attachment of and forfeiture of property, if I have to attach and forfeit a property. So plain reading of 105A, it brings in some definition clause. In this chapter, unless the context otherwise requires, contracting state means any country or place outside India in respect of which arrangements have been made by the central government with the government of such country through a treaty or otherwise. Why they say country or other place? Other place might be, there are some legal individual entities available in the world which are not designated because of certain definitions and international understanding to be called as a country, or maybe some countries which we think are not countries. For example, Vatican. Vatican is not not a place. It's called as a company. Legal definition of Vatican is of a company. So uh, any other place which is country or anything which is defined, any place which is in position of lawfully signing a treaty with the government of India or any such contract, this company is called a contracting state. Identifying means includes establishment of a proof that the property was derived from or used in the commission of an offense. Proceed of crime means in derived or obtained directly or indirectly by any person as a result of criminal activity, including crime involving currency transfer or value of any such property. Property means property and asset of every description, whether corporeal, incorporeal, movable, immovable, tangible, intangible, and deeds and instrument evidencing title to or interest in such property, which might be uh, derived or used in the commission of crime. So everything which is related to crime. Tracing means determining the nature, course, deposition, movement, title, or ownership of the property has to be traced. Now, if we see from the section 105A, so contracting state we have seen from the previous section, the mother section 105 also. Identifying is establishment of proof that the property was derived from or used in commission of offense. So it is identified that the property was either taken or created or derived from the some offense which is created, or the property is used in some kind of crime. So what is the importance? It plays a vital role in case involving confiscation or seizure of property linked to criminal activity. It underscores the necessity for clear evidence to trace connection between the asset and criminal asset, ensuring the justice is applied correctly. Proceeds of crime is the term reflects a broader understanding of the implications of criminal activity on individual assets, allowing law enforcement to address not just the crime itself but also the financial gains that result from it. And the definition is crucial in case of money laundering and financial crime. Property. So, this comprehensive definition of property allows for a broad interpretation of property in relation to criminal investigation, enabling authorities to pursue confiscation and forfeiture of diverse asset type involved in unlawful activity. So, whether it is corporeal, physical, or incorporeal, which is intangible. So, in any way, the this is applicable. Tracing is a definition which is significant for investigation concerning financial crimes. Asset recovery, property right, tracing is essential for establishing link between property and the criminal activity and in turn to the people who are connected with it. And that is also something related to the financial crime and property crime. So there is to bring in a clarity and precision, the definition clause are added to be used in the clauses further beyond 105. And that is how the interpretation would be done in other sections which are proceeding after section 105. So 105 talks about assistance to secure transfer of persons. Now 105 ABCD, all these sections are connected to the main section 105. So 105 you have to keep in mind, which was we discussed here in the section 7, which was reciprocal arrangement. We talked about it in terms of summons, warrants, and the people and the materials to be produced from the perspective of either asking for that to a country outside India or within India, a place which is out of jurisdiction, or when you receive such a request from other country or other out of jurisdiction place in India. So this is all belonging to 10 connected to 105. So in you have to keep in mind 105 always when you talk about any of the sections to 1 by 105 alphabetical, except Y, which is a definition. Now, when a court in India, in relation to criminal matter, desires that a warrant for an arrest of a person to attend or produce a document or other things issued by it shall be executed in any place in a contracting state, it shall send such warrant duplicate in such form, such court, judge, or magistrate through such authority as the central government notification specify in this behalf and the court, judge, magistrate, as the case may be, maybe shall cause the same to be executed. Now, we saw in 105, in either case, we when we receive such a request, we consider it as if it is done by uh, the judge or magistrate of the same jurisdiction. So, very same way, it has to be executed by the contracting company, a country, uh, as if it is given and ordered by the same jurisdiction, magistrate or court. And that arrangement is already done through the treaty and various agreements with the state government. And whom to send is also part of the such a notification once the treaty is done, where the responsible people and corresponding people who can communicate and talk to each other is already designated people are already listed out. Notwithstanding anything contained in this code, if in the course of an investigation or an inquiry into an offense, an application is made by the investigating officer or any officer superior in rank to the IO that the attendance of a person who is in place in contracting state is required in connection with such investigation inquiry, then the court is satisfied that such attendance is so required, it shall issue a summon or warrant in duplicate against the said person to such court, judge, magistrate in such form as central government may notify. Now, first one was talking about in the same situation when an arrest, production of document or person is required for some or other reason, it has to be sent to those courts or judges or magistrate, which is notified in the state government. So this is talking about whom it has to be said. Now, the part two, which talks about in the same scenario, if it is required that such inquiry, the court is satisfied, attendance is required of one of the person. So when you are sending it to whom, which is designated in that particular notification of government, part two talks about how it has to be sent. So once they have a treaty, the part one talks about not only whom it has to be sent, the part two also says it has to be in the format which is specified on behalf during this treaty, or if there is a standard protocol. Part 3 says where a court in India, in relation to criminal matter, has received a warrant for arrest of a person requiring him to attend and produce a document, other things, in the court or before any other investigating agency issued by a court, judge, magistrate in a contracting state, the same shall be executed if it is from the local court. So if we receive, we follow it as a similar same jurisdiction any other magistrate has ordered. Now, 4 says where a person transferred to a contracting state pursuant to subsection 3 is a prisoner in India, the court in India or the central government may impose such condition as the court or government deems fit. So, if the person who is being seeked by the other country, the contracting state, and if the person is already a prisoner, then the government may impose such conditions as a court or government deems fit. This is very, very important in terms of the various mafias who might have committed crime in multiple countries, and then they're required to be present in for some connection, some crime in some other country, which is the contracting state. Number 5, where the person transferred to India pursuant to subsection 2, 1 and 2 is a prisoner in the contracting state. Now you have received somebody who is a prisoner in that state. The court in India shall ensure that the conditions subject to which the prisoner is transferred to India or complied with, and such prisoner shall be kept in such custody subject to such condition as the central government may direct in writing. So if you receive now prisoner, then you have to follow such conditions which is given by central government, which is in turn as agreed by the other contracting state. So this is the one which talks about how you want to receive or send a criminal or a person who is not a criminal, but then required by the other state, or you require it from the other state, which is a contracting state. So this is what is mentioned in section 105V, which is assistance in securing transfer of persons. So the instance of issuance of warrant for execution of such in a contracting state is an authority of Indian court. They have an authority. They can send the warrant as per the government GR, and the receiving court, where we have a treaty, has a responsibility to ensure the compliance of that particular warrant happens. It is a very controlled transfer, and it is a court's decision in both the side. Coming to section 105C. So assistance in relation to orders of attachment or forfeiture of property. Now, when a court in India has a reasonable ground to believe that property obtained by any person is derived or obtained directly, indirectly by such person from the commission of any offense, it may make an order of attachment or forfeiture of such property as it may deem fit under the provision of 150D, 150J further. Where the court has made an order for attachment or forfeiture of any property under subsection 1, and such property is suspected to be in the contracting state, the court may issue a letter of request to the court or an authority in the contracting state for execution of such forfeiture of property. Where a letter of request received by central government from a court authority in a contracting state requesting attachment for future property derived or obtained directly, indirectly by any person or commission of from the commission of any offense committed in that contracting state, the central government may forward such letter of request to the court as it thinks fit for execution according with the provision of 150D to J, and the case may be, or any other law for the time being in force. This is also primarily something which is related to financial crimes. When somebody commits a financial crime, these provisions are also related, where the forfeited property might even be a bank account. So when we talk about a bank account and the money from a Swiss bank which has to be forfeited, although we don't have a treaty, but if we had a treaty earlier, then we could have used Section 105C for sending a letter for forfeiting and that account, of course, provision to the specific banking laws, etc., etc. So 105C is something which is a precondition where the reasonable ground has been provided to the other party, whether it's India, which receives one from the contracting state, or the contracting state which receives from us to forfeiture towards the forfeiture of the property. And this is something very, very interesting that you can operate it within the scope of these contracting state, and which helps you to extend the power of the courts up to the attachment of the properties also in those countries as well. But it has to be done on a reasonable ground. The very first line says when a court is India's reasonable ground. So it has to be have a very reasonable ground. So it is not very easy until and unless reasonability is not proved, it cannot happen. This is a critical measure aimed to prevent the use of illicit gain by somebody. Issuance of letter of request is a very important step. Either it is received or sent, and this facilitates the international cooperation, which gives under a special formal request under the format which is agreed within the treaty of the countries. Handling foreign requests for attachment or forfeiture, if it happens, it is considered to be sent from any other magistrate of the same jurisdiction and it is executed. Coming to 105D to J now. The court shall, under subsection 1 or on receipt of letter of subsection 3 of section 105C, the previous one. Hmm. So 1 and the 3 of subsection 1 and 3 of section 105C. Direct any police officer not below the rank of sub-inspector of police to take all steps necessary for tracing and identifying such property. 2. The steps referred to subsection 1 may include any inquiry, investigation, or survey in respect of any person, place, property, asset, document, book of account in any bank or public financial institution, or any other relevant matters. Any inquiry, investigation, or survey referred in subsection 2 shall be carried out by officer mentioned in subsection 1 in accordance with the such definition issued by the said code in his behalf. Now, 105D has components like the court's directive to police officer. So this is something which is a directive which is given to the police officer. So there is an authority to act which is provided by the court, which upon determining that specific property may have been unlawfully acquired, or upon receiving a letter of request in accordance with a subsection 3 or 105C, the court is empowered to direct any police officer specifically on one not below the rank of sub-inspector. It cannot be below sub-inspector to initiate action for tracing and identify such property. So the court shall under section 1, subsection 1, or on receipt of letter of request. So if the court believes it is the case, or if the court receives a request from a contracting state, in both the cases, the court may direct a police officer not below rank of sub-inspector. Because in both the cases, it is the property we are talking about is within the country. Now, the purpose is to mobilize the law enforcement resource in identifying the potentially illicit gain, because somebody has to go ahead and investigate that, aiding in the broader effort to combat crime and recovery property obtained through unlawful means. So it is related to recovery. When we talk about the steps of tracing and identifying the property, remember tracing and identifying were definitions in section 105A. So inquiries is something which is conducting, the police officer is allowed to conduct inquiries by interview, talking to people, relevant parties. He is allowed to investigate whatever related to investigate related to the financial crime or property crime, and the survey is from performing physical survey of location where the property may exist to store. So he may have to walk out into the place where exactly this property is situated. And then assessing a documentation is also allowed, where he can also assess documents of various kind, which is part 2. So in part 1, in case there is a suspicion to the court, and part 3, if there is a request received from the contracting state, not below the rank of sub-inspector, a police officer may be directed, and the person is do inquiry, investigate, and survey by visiting the place, and he can also go through any document. Any inquiry, investigation, surveys referred in subsection 2, what he will doing there shall be carried out by an officer mentioned in subsection 1, so sub-inspector, in accordance with such directions issued by the said court in his behalf. So when the court issues an order for this investigation, they also issue the directions in this direction. So the person has to carry out the action, but only through the instructions given by the court and in the scope of that particular thing. So it gives a very structured investigation framework and provides a very good due process to identify unlawfully acquired property. So this section is about identifying unlawful property in case of the courts himself, if they have reasonable understanding that it could be the case, or if the request is received from a contracting company. So once you have identified, you will seize it. So 105, we talk about seizure of or attachment of property. So now you have identified. Now, where an officer conducting an inquiry or an investigation under section 105D has reasons to believe that any property in relation to which such inquiry or investigation is conducted is likely to be concealed, transferred, or dealt with in any manner which will result in disposal of such property, he may make an order for seizing such property, and where it is not practical to seize such property, he may make an order for attachment directing that the property shall not be transferred or otherwise dealt with except with the prior permission of the officer making such order, and copy of such order shall be served on the person concerned, and any order made under subsection 1 shall have no effect unless the said order is confirmed by an order of a said court with a period within a period of 30 days of its being made. So 105E, once we have identified the property which needs to be attached, now we are doing a seizure of the or attachment of that property. So what does section 105E says? Number one, authority to seize or attach property is the subject of this particular section. It has to be reasonable belief required. So when an officer is conducting an inquiry or investigation in 105D, the previous one, they may have reason to believe that a property involved in this inquiry is at a risk of being concealed. Somebody will take away, or transferred, or otherwise disposed of. Somebody might sell it. So this necessitates a prompt action to prevent such occurrence. So a prompt action is required. That is why the section is there about the seizure of the property. So if the officer believes there is an imminent risk and of disposal, they may issue an order to seize the property directly. This allows for immediate action to ensure that the asset is secured for legal proceedings. Attachment as an alternative. So in case where it is not practical to seize the property physically, the officer may opt to issue an order of attachment. This order prevents the transfer or dealing with the property until proper investigation are concluded, further securing the asset for judicial scrutiny. So this ensures the evidence is present for the judicial scrutiny, and there is a prior permission required. If we see part 2, the attached property may only be transferred or dealt with after obtaining prior permission from the officer who issued the order. This required service has to be maintained and control over the property and safeguard against unlawful action, and that is why it says the said order is confirmed by an order of the said court within a period of 30 days from the seizure being made. So confirmation of order is also one of the element in this particular section, which talks about temporary nature of order. So this order is of a temporary nature, 105. And what is the importance of 105E? It prevents the asset evasion. So asset might not get lost or destroyed. It is secured. The legal safeguarding by having the right evidences in place, physical evidences, and that is how it also helps in the investigation as well. Coming to 105F, management of property seized or forfeited under this. Now you have already forfeited the property. So 105D, you have done an investigation. E, you have seized it. Now you have to manage. So the court may appoint the district magistrate of the area where the property is situated, or any other officer that may be nominated by the DM, mostly SDM, to perform the function of an administrator of such property. The administrator appointed under subsection 1 shall receive and manage the property in relation to which the order has been made under subsection 1 of section 105E or under section 105H in such manner and subject to such conditions as may be specified by the central government, and the administrator shall also take such measures as the central government may direct to dispose of this property which is forfeited to the central government. So court may appoint a district magistrate. So this will be coming under the control of the uh, executive magistrates, because the courts, it's not courts job, the judicial courts not, it's judiciary is not empowered, or it is not a role of the plain role of the judiciary to do any administration. It's job of the executors, that is the executive magistrates. So 105F has the ingredients like appointment of an administrator. So this talks about an appointment of an administrator by the authority of the court. So court has authority to appoint a DM or any other such magistrate, executive magistrate, as an administrator of the property who is administrating. So why this is purpose is for this appointment is it is intended to ensure that there is a person responsible to oversight and manage the property, and ensuring that the legal and operational standards are definitely established. What is the management responsibility mentioned here? So the administrator once appointed is taken into managing the property in relation to which an order has been issued order. The court has issued order. So subsection 1 of section 105E, which is pertaining to the seizure of the property, is suspected to be unlawfully obtained or linked to criminal activity, and H, which is related to property that may be forfeited under certain legal context, which will come forward in a while. In all those cases, this is applicable. And conditions and manner of management is also mentioned under this section, where the management of such property must be conducted in accordance with the conditions and guidelines applied by the central government. So central government has guidelines around those things, and this ensures that consistency in how the seize and the forfeited property happens, and it is safeguarded and saved for the legal requirements. So disposal of is also part of this particular section, where as per the direction from the central government, either you manage it or dispose it. So there is a structured way and rule around disposing it also. So overall, section 105, we talks about oversight and accountability to be created by a administrator, a legal clarity established in the property management and the disposal process. And it avoids the prevention of misuse. In 105G, notice of forfeiture of property. So if a result of the inquiry, investigation or survey under section 105D, the court has reason to believe that all or any of such properties are proceeds of crime, are it may serve a notice upon such person, calling upon him within a period of 30 days. Specified in the notice to the indicate the source of income, earning or asset out of which or by means of which he has acquired such property. The evidence on which he relies another relevant information and particular, and to show cause they will all or any of such properties, as the case may be, should not be declared to proceeds of crime and forfeited to the central government. And point 2 says where a notice under subsection 1 to any person specifies any property as being held on behalf of such person by another person, uh, a copy of the notice shall also be sent served upon such other person. So this is notice of forfeiture, which is mentioned in section 105G, and what it says is it's a court's authority that following an inquiry and investigating into the survey carried out under section 105D, the court has reasonable ground if to believe that the certain properties which are there are used in proceeds of crime. So it may serve a notice to the individual affected by this determination and the person referred to as the person affected. So the content of the notice would be, it will ask for it will affect the impact the individual, and within a straightforward period of 30 days time, the person has to respond on the source of income, the any other evidence supporting that legitimacy of his property claim, and relevant information. Whatever relevant information is asked, the person has to provide within 30 days, and a show cause is required. So individual person may come back and put a show cause in this situation to come out of the situation. Importance of this section 105G is it is again a due process establishment clarity, but it stops any arbitrary action and facilitates a judicial oversight. 105H is a forfeiture of property in certain cases. So there are certain cases the court may consider the explanation, if any, to the show cause notice issued under section 105G, previous one. So any notice has been issued. So the court may, after considering the explanation, if any, to the show cause notice issued under section 105G and the material available before it, and after giving to the person affected, and in case where the person affected holds a property specified in the notice through any other person, to such other person also reasonable opportunity of being heard by order, record of finding whether all or any of the property in question are proceeds of crime, provided that if the person affected and in case where the person affected holds any property specified in the notice through any other person, such other person also does not appear before the court or represent his case before it within a period of 30 days specified in the show cause notice, the court may proceed to record a finding under this subsection ex parte on the basis of the evidence available, which is anyways a normal rule, where the court is satisfied that some of the properties referred to in the show cause notice are in proceeds of crime, but it is not possible to identify specifically such properties, then it shall be lawful for the court to specify the properties which, to the best of its judgment, are proceeds of crime, and records a finding according under subsection 1, where they will record it, and where the court records a finding under this section to the effect that the property is in proceeds of crime, such property shall stand forfeited to the central government free from all encumbrances, and where any shares in company stand forfeited to the central government under this section, then the company shall, notwithstanding anything contained in the Companies Act or the articles of association of a company for which register the central government as the transferee of its shares. Now 105H, what it says? It says that the court procedure following the show cause notice. So when there is a show cause notice we talked about, what is the court procedure after the show cause notice? So number one, if there is an opportunity to respond, it is given. So the person affected can respond. The court is required to consider any explanation provided by the individual affected following a show cause notice issued under previous section. The court must also evaluate now all relevant materials before it to understand. Importantly, it must provide the uh, person affected as well as the third party holding the property, who is managing the property, a reasonable opportunity to be heard. So it gives opportunity to both the parties, even the parties directly affected or the third parties. It also talks about the ex parte proceeding in the same first part, which is if the affected person or any third party fails to appear before the court, does not represent their case, either of the way, within the 30-day period specified in the show cause notice. So there's a 30-day notice we mentioned is part of the show cause notice. So within that period, if the affected person or the third party or whomsoever is not appearing in front of the court, and when the show cause notice is where the show cause notice is issued by, and the court retains an authority to proceed with ex parte finding. It's court discretion. They want to go for ex parte after 30 days, they can go, or else they can wait also if they want. So court can make a decision based upon the evidence presented without the input of the affected party. Then it becomes the play of the court itself that they do it depending upon uh, how they want to proceed. Now, it also talks about identification of proceeds of crime, which means if you see part two, it talks about that. So it should be the court determine that the certain properties which are referenced in the show cause notice, if they are indeed in the proceeds of crime, yet it cannot specifically identify each property. The court is empowered to designate properties it believes to the best of the judgment or proceeds of crime. So there is no differentiation possible. It can go ahead and decide upon its own uh, mind what has to be considered in terms of understanding it to be that property. So this approach acknowledges a practical challenge in case of multiple assets and complexities in tracing the origin. So court can just go ahead and do it. Somebody can challenge if they have a problem later. Now there is an automatic forfeiture which is also mentioned further in this section, which is when the court records a finding that any property is in proceeds of crime, that property becomes forfeited to the central government, effectively free from all encumbrances. This provision directs that the property will no longer be considered the as individuals and will instead belong to the state. That is reinforcing the state right to reclaim the asset derived from the criminal activity. So it is reclaiming which is part of it. Now it also talks about forfeiture of shares. So if a share in a company is are forfeited under this law, under this section, the company must, regardless of existing regulations, including Companies Act or any such act, immediately register the central government as the transferee of such share. So if these shares are forfeited, they'll be transferred in name of the central government. The clause is particularly significant as it is something which ensures that the state can effectively claim ownership of a share, thereby controlling acts linked to criminal activities without being hindered by procedural formalities typically required in share transfers. So it becomes automatically transferred there. So what are the importances of section 105H? It strengthens the asset recovery. It Through this, the asset recovery happens very strongly. There is a judicial oversight which has to be there, is inbuilt, and this is also in interest of public because those financial losses may indirectly hit the public also, and it also facilitates the corporate compliances. So in regulating shares, whatever has to be done, those compliances are also complied with. So this is basically in lieu of the forfeiture, for failure of the property in certain cases. Now, coming to the Section 105, free in lieu of forfeiture. So when the court makes a declaration that property stands forfeited to the central government under Section 105H, now previous one, all are connected. And it is a case where the source of only a part of such property has not been proved to be satisfactory, satisfaction of the court, it shall make an order giving an option to this person affected to pay in lieu of forfeiture a fine equal to the market value of such property. Before making an order imposing a fine under subsection 1, the person affected shall be given a reasonable opportunity for being heard, where the person affected pays the fine due under section 1. Such times may be allowed in the behalf. The court may by order revoke the declaration of forfeiture and such property shall stand released. Now, this is a scenario where now you have made an appeal and you have failed it and the forfeiture is happening. Now, again, there is an option which can be given to by the court to you is there is a part of partial forfeiture scenario where if a part of the property is being forfeited and then the court can come back and give you an option to pay in terms of in the market value of the property instead of forfeiting that property. That is possible, and the person will be given a reasonable opportunity for being heard as well. Now, if the person under some reason believes that the forfeiture is not right, it is by rule he is allowed first to put such appeal and claims to ensure that the property is declared out of forfeiture, or in case the person agrees and pays a fine, then also there is a declaration of forfeiture is withdrawn and the property is stand released. So the purpose of the fine is to give a fair and just alternative to complete forfeiture. So if you do not want to lose the part of the property, you pay and you continue having the property, and the purpose of fine is also resolved. But it has to be at the same price at the market's property value. And purpose of the fine basically to provide a fair and just alternative so that you don't lose that particular property. Right to hearing is still upheld here in this section, and it's not that only because the fine is can happen in lieu of forfeiture, that option only can be given. Still, the doors for appeal are kept open so that if that happens towards the benefit of the person, the person may not need to lose the property and get it forfeited by the state government. The person might still enjoy the property by paying the same market value in lieu of that particular forfeiture. So the payment process is individual who decide to pay a fine or they want to get the property forfeited. It's up to them. And this is a encouraging compliance, which is safeguarding the individual rights and giving flexibility to the person. By, in spite of being in any situation, the person is respected as an individual and his rights are also considered. 105J, certain transfers to be null and void when the after making of an order under subsection 1 of 105E. What was the 105E? Just to refresh, management and properties seized or forfeited under this chapter, where the district magistrate were putting an administrator. So after making an order under subsection 1 of section 105E or the issue of a notice under 105G, so a notice of forfeiture of property. So both has happened. Administrator was appointed or a notice of forfeiture of property is issued. Any property referred to in the said order or notice is transferred by any mode whatsoever. Such transfers shall for purpose of proceeding under this chapter be ignored. And if such property is subsequently forfeited to the central government under section 160H, then the transfer of the such property be deemed to be null and void. Why? Because then this is a trick. You wanted to issue quickly the property to somebody else for the sake of creating a third party interest and then making the situations complex. because the order is against your property. By the time you transfer the interest of the property to somebody else, the interest of the property is already changed, and further complexities could be built up. And to avoid that, this particular section makes it null and void. 105K. So 105J, there are certain key ingredients. One is it's a post order or post notice transfer. So once post and order has happened, post and notice has happened, and then a transfer happened. In those scenarios, this is applicable to prevent them and making them null and void. Notification of transfer on forfeiture. So forfeiture of property or purpose of nullification happens only if the property in question is subsequently forfeited to the central government. Any prior transfer out to that property will be deemed null and void. So it can only go to the central government further in that case. And the purpose is that to ensure that the individuals cannot evade forfeiture or attachment by transferring property to another party, third party. So it reinforces the legal principles and procedures. So what is the important of 105J is it prevents evasion of law. Law evasion is prevented. Clarity in legal proceedings on why this scenario cannot be uh, is not allowed, and preservation of the public interest because this is nothing but public's money, and it strengthens the legal framework. Coming to last section, second last section, 105K, procedure in respect of letter of request. We talked about letter of request, where letter of request is received or sent from the contracting state. So every letter of request, summon or warrant received by the central government from, and every letter of request, summon or warrant to be transmitted to a contracting state, both the scenarios under this chapter shall be transmitted to contracting state, or as the case may be, sent to the concerned court in India in such form, in such manner as the central government may by notification specify in the behalf. So it says when you send it out of jurisdiction in India, out of jurisdiction outside India to the contracting state, in either of the cases you are supposed to bring in the format which is provided by the central government by notification, especially for this regard. So exists a specific format which has to be followed, and so it's an authority of the central government which is highlighted here, where they can bring in through the notification what format, what information has to go. So the format and the manner also, how it has to be served, is part of it. This is about 105K, and application of this particular chapter is written as a concluding section. The central government may, by notification in the official gazette, direct that the application of this chapter in relation to a contracting state with which reciprocal arrangements have been made shall be subject to such conditions, exceptions, or qualifications are as are specified in the said notification. So this all reciprocal arrangement is happening with the states, the states which are contracting states. So the central government may, by notification of the official gazette, direct the application of this particular relationship with a contracting company. So by the time it publishes, then the relation is, once it is established, it is published, and the relation is then open for execution, where the reciprocal arrangements can be made. And these conditions, exception or qualification, whatever is limit mentioned in this notification, is only applicable to those sections for those countries, which is what 10150L says. So it says authority of the central government basically is in issuance of the notification, specification of the terms and condition between India and the participating country, the contracting state, and the purpose of the condition is also mentioned in that particular document, which is treaty, which is signed with the country, the contracting state. And the very important thing is this is facilitating a smooth international cooperation, which is announced by the government, central government GRs, gadgets, and providing legal certainty and promoting adaptability and streamlining the legal process. So this is what is in chapter 7 and 7A of CRPC, which we concluded today. I'll just stop the recording and then we'll continue.